The way this came about was the International Religious Freedom Committee for the J. Reuben Clark Law Society asked us to host another symposium here in Denver. And we got together as a board and talked about how we wanted to handle that. And a number of the board members came up with the idea that they felt like too often when we have religious freedom symposia, we end up talking over the heads of everybody. And we get lost in the weeds on cases and that kind of stuff. And people who practice in the area get really excited about some fact-specific case, and no one ever gets anything out of it. And they thought it would be good to have a meeting where we get all the lawyers together who are interested and talk about kind of the basics of religious freedom and give a basic understanding so that you can all then go back into your stakes and wards or wherever you are, or if you're non-LDS, to your congregations, and talk about it in an intelligent way and help inform people about what the issues are and what's going on. So that's kind of how this came about, and I hope I can help facilitate that in some way. I'm just going to jump right into it. Hopefully you know my background a little bit. Our firm obviously does a lot of business litigation and business representation, but we also have a religious institutions practice group. I chair that practice group. I teach at the University of Denver Law School on religious liberty law and publish a lot in the area. Religious freedom in the United States comes from two clauses in the Constitution, largely. That's the basic foundation. Now, there are other clauses, there are other statutes, but the basic premise comes from the first two clauses of the First Amendment. The first clause is that Congress shall make no law respecting an establishment of religion. That's the Establishment Clause, and that's where this basic notion of separation of church and state comes from. The second clause is Congress shall make no law prohibiting the free exercise of religion. So you have these two clauses that form the backbone of religious freedom in the United States. They're referred to as the first freedoms because they're the very first things listed in the First Amendment. When you actually look at religious freedom and try to understand it, what you find is that you have to have both clauses for religious freedom to really work. You have to have the principles that are derived from the Free Exercise Clause, and you have to have the principles that are derived from the Establishment Clause. If you lose either one, religious freedom is most likely going to topple. So keep that in mind. I'm going to dig into what these principles are, but it's really important to understand that religious freedom comes from both clauses. The question is, why did the founders think it was so important to put the religion clauses in, and why were they put first? Obviously, it was top of mind. It was something that they were worried about. So I want to dig into a little bit about why religious freedom matters, why it is important, and why it was important to the founders. One key principle that I think a lot of people lose sight of is that all of us have religious beliefs. Now, my friends on the far-right Christian side bristle when I say that, and my friends on the far-left atheist side bristle when I say that. But the reality is, when you think about it, all of us have answers to the questions like, is there a God? Why are we on this earth? Where do we go when we die? Certain questions of morality. We have answers to those questions. Our answers may be as simple as, I don't know, right? Is there a God? I don't know. Well, that's called an agnostic. Those are religious beliefs, and those religious beliefs deserve to be protected. So when we talk about religious liberty, it's not just some freedom that protects only people on the far right or only Muslims trying to get into the United States. It's a freedom that protects everyone. And it protects all of us equally if we respect it and treat it appropriately. If you look back at the founding, the founders had a number of reasons for wanting to protect religion. One of them was to reduce conflict. This is a cute little cartoon that kind of shows how I think a lot of people feel about religious freedom and how they feel about religion generally. They think that religion is the cause of war. Okay? But if you understand the notion that we all have religious beliefs to some degree or another, then you realize that it's not religion that causes war. It's actually a lack of religious freedom that causes war. When governments are co-opted to force one religious belief onto someone else, or to take away someone's religious exercise, generally that leads to uprisings, rebellion, and eventually violence. So it's not religion that causes war, it's a lack of religious freedom, and the founders understood that. Here's a quote from a scholar on religious liberty at the University of Virginia. He wrote, "In history that was recent to the American founders, governmental attempts to suppress disapproved religious views had caused vast human suffering." This is an artist's depiction of the 30 Years' War in Germany. It was largely a religious war. It morphed over time into something much broader than just a religious war, but at its root it was a religious war. Over 20% of Germany's population were killed as a result of the 30 Years' War. And you had centuries of battles like this up to the time of the founding, up to and including life in the colonies. The founders knew this, and they were trying to find a way to reduce that level of conflict, and the religion clauses were their solution. Another reason for religious freedom, and another reason the founders were trying to inculcate it here in this new country, was that they were part of a grand experiment, right? For the first time in American history, they were going to try to have a government that was ruled by the people. And at the time, there was a philosopher named Montesquieu who espoused this notion that the people cannot govern themselves unless they have virtue, unless they have an understanding of morality. Otherwise, it will just lead into chaos. The founders understood that, at least to some degree, and they believed that religious freedom would help promote that, would help promote a people who could then govern themselves. So that was yet another reason the founders wanted these clauses in the Constitution. Finally, there's a theological purpose behind the clauses. Okay? Generally speaking, when you think about people who are deeply religious and have deeply religious commitments, their religious duties tend to supersede their societal duties. That is to say, people with religious duties are willing to die for their religious beliefs. They are willing to be imprisoned by government for their religious beliefs. They're willing to immigrate, right? They're willing to really endure all sorts of bad treatment for their religious duties. So coercing obedience to religious doctrine through the government is theologically ineffective. What it results in is kind of a watered-down faith to which there's no theological benefit. So it's actually a detriment. What you end up with in countries where you see this happening is those people who are faithful with the government-sponsored religion really have no faith at all and are barely involved. And other people are being oppressed and having their faith crushed. So there's a theological value then to allowing freedom for everybody and to create an environment where if religions are going to thrive, they're going to thrive on their own without the assistance of government, which means they have to persuade people to join their faith through their lifestyle, through their examples, through the spirit people feel when they walk into their doors, right? Through what they see it, how they see it benefiting other people's lives, and that creates much more vibrancy. So there's also this theological argument for why religious liberty is important, and the founders were very much aware of this. It's something they wrote and talked about. So, when you think about all of those purposes, you realize that religious freedom is something that protects everyone in this country. Too often in our modern dialogue, we tend to think it only protects people on the far right, and that just simply is not the case. It is something for all of us, and the question is, how can we continue to protect it while addressing other societal issues that come up over time as society changes? And that's what we're going to delve into a little bit now. So I've taken my little temple here. I'm not like the world's greatest expert with PowerPoint, but I made my little temple here of religious freedom. And I mentioned before that what we had is the free exercise principles on one side, the Establishment Clause principles on the other side. I've tried to condense these down into a simple concept as I can, so it's easy to kind of digest and explain to lay people. On the free exercise, well, let me start with the Establishment Clause side. We have this notion that government should not disfavor or favor any one religion. It's a relatively simple principle, and it's something you can think about. If you ever see government favoring one religion over another in schools, on government property, in the halls of Congress, that kind of a thing, it should raise a red flag. Similarly, government should not burden religious exercise in any way. That comes from the Free Exercise Clause. Both of these principles are subject to the compelling interest test, right? We can see a world where government should burden religious exercise because it has a compelling interest to do so. For example, if I believe that my religion mandates that I sacrifice 5-year-old children once a year, we could all agree, I think, that the government has a compelling interest in not allowing me to engage in that conduct. Similarly, you could think of scenarios where, say, a particular religious sect should be treated less favorably than others because of maybe a timely threat that they might pose. You see it come up sometimes in various situations. So I want to emphasize here, this is not the current state of the law. The current state of the law is a jumbled mess. It's not my fault, I promise. I blame it mostly on Justice Scalia, but we'll get to that in a little while. This is what the law would look like if we truly had religious freedom as robust as we could in the United States, which we don't have right now. But this is the aim that we're all shooting for. and try to remember this. I'll come back to it kind of at the end so we get it summarized in 2 questions we can ask ourselves if we're ever trying to figure out if religious freedom is threatened. I'm not going to spend a lot of time today on the Establishment Clause issues. Both of these topics could be an entire semester's worth of material, and when I teach this at the law school, it is an entire semester's worth of material. I'm going to focus mostly on the Free Exercise Clause. I'll get back to the Establishment Clause principles a little bit, just to give you a sense of it. On the free exercise part, I want to help you understand what we talk about when we say government should not burden religious exercise, because obviously we have to figure out what do we mean by religious exercise. Thomas Jefferson, in a statement he made around the time of the founding, created essentially kind of a continuum where religious exercise, in its most outward bound form would be conduct, followed by worship, speech, membership in a group, and finally belief. The government's right to regulate religious exercise then decreases as you go down this continuum, when Jefferson was talking about this. So when we talk about conduct, think of killing a 5-year-old child, right? We would all agree the government has the greatest authority at that point to regulate religious belief. But as you go down this continuum, you get to the point when you're talking only about belief, where you say, well, government really should have no authority whatsoever to regulate my beliefs. This is important because it has been challenged and actually is being challenged today, and I'll get into it in a little bit. But when you think about religious exercise, try to keep this continuum in mind because it'll help you identify whether or not someone's religious exercise is being burdened. Today, religious freedom is under threat. It's not always under threat the way people tend to talk about it, especially in the media. As you watch things going on, you actually see it being under attack from both sides. What tends to happen is that folks on the political left are attacking the free exercise of religion. And I'm using broad strokes here, right? It's not as if every attack on free exercise comes from the left or every attack on the establishment comes from the right. But in broad strokes, generally what we see are attacks on free exercise tend to come from the political left, and the attacks on the Establishment Clause tend to come from the political right. I'm going to explain with a timeline in a second why this is the case here. For the attacks from the political right, think of something like the notion of a Muslim ban. Now, the ban that Donald Trump has out there now is not a Muslim ban per se. It's gotten complicated and it's been nuanced and changed. So I'm not talking about what is actually in place. During the election last year, about a year ago, he had proposed just the notion of a Muslim ban. That got 80% support from Republicans at the time. In one survey through Pew, 80% of Republicans said they didn't feel like banning a religious group because of their religious identity would be a violation of American principles. So just think about that for a second. You have folks on the political right who think, yeah, it's totally fine to ban Muslims as long as you don't ban my church, right? But that doesn't work. What you're doing is disfavoring one religion over others. So we see that often. Now, the free exercise side of this is a little bit more complicated, and it's got a long, tortuous history that I'd like to walk you through just to give you a sense of it. We sometimes have this sense, because of more modern history, that religious freedom in the United States has always been healthy and robust, and it's only in the last few years that it's really been challenged. It's a little bit more checkered than that. The Mormons in the room should understand that as well as anybody. But if you look at the history, clauses were put in place around 1790. There was a few highlights along the way. There was a Catholic priest who, well, let me back up. These cases all tend to follow the same pattern. You have a majority in control of some governmental body. It could be at the city level all the way up to the federal government. They impose some type of regulation or law. That regulation or law inhibits someone's religious exercise. Usually, it's someone who's of a minority religious belief or exercise, or at least it's someone whose religious exercise is not consistent with the majority who's in power, right? Because if it was, the majority who was in power would have exempted them out as part of the legislative process. So what you end up with, and you see these cases all the way through. So going all the way back to this time, we actually exempted Quakers out from having to fight in the Revolutionary War. And there's all sorts of quotes from George Washington and Thomas Jefferson and others saying, look, if it doesn't pose a basic, I'm going to use words they didn't use, but a national security risk to allow them to opt out of fighting, then that's okay. We'll find an accommodation for them. Okay, so you had some positives from the founders. Once the founders all passed away and we got moving forward, there really wasn't a lot of really great examples of free exercise. We saw a few instances where a Catholic priest didn't want to testify in court. Someone had confessed to him of stealing jewelry, and the police wanted to force him to testify as to who was stealing that jewelry and or who had stolen the jewelry. And he said, "Look, I'm not going to tell you, and I'll just go to prison, but I'm not going to tell you." And a far-thinking judge in New York, DeWitt Clinton, ruled that, you know what, we're not going to force him to testify. So to this day, we don't know who stole the jewelry and who went and confessed to him. Aside from that, though, we had a long period of kind of painful burdens on religious exercise. Most prominent, of course, is the LDS Church. Those burdens on religious exercise resulted in exactly what the founders would have expected. There was violence, there was bloodshed, thousands of Mormons were killed, Mormons retaliated and killed other people. It led to the Utah War, people immigrating out of the country. All of the conflict that you would have expected from a lack of religious liberty happened with the Mormon cases. And then we reached 1890. There was a case called Davis v. Beeson. It doesn't get celebrated as much today, largely because I think it's been overruled. But if you go back to Jefferson's Continuum, Davis v. Beeson was an interesting case. It came out of Idaho, and there was this little town in Idaho. Actually, I think it was the state of Idaho, had a law on the books that said, if you practice polygamy, if you are a member of a church who teaches polygamy, if you preach that polygamy is some type of spiritual principle, and even if you have the belief in an organization that teaches that polygamy is okay in some circumstances, you cannot vote. That was the law that the state of Idaho passed. In 1890, the Supreme Court upheld that as constitutional. So essentially what they did was they gutted the First Amendment, at least the free exercise clause of the First Amendment, right? They said, look, if your religious exercise is repugnant enough to us as a majority, we can regulate you all the way down to belief, and you have to deal with it. So that was on the books. There was a relative quiet period, in part because during this time in American history, right, the East was still going through Reconstruction. Mormons were off in the West just kind of doing their thing. There weren't as many religious minorities as we have today in the country. Those that were there were, quite frankly, being oppressed. But there weren't a lot of cases being churned up. There just weren't a lot of minorities testing it. Then around 1940, you started to see a revitalization of religious liberty. A lot of it was driven by the Jehovah's Witnesses. A series of cases. One, they were proselytizing I think in Connecticut, and they had a record player, and this album that they were playing said negative things about the Catholic Church. And they went into a heavily Catholic neighborhood, started playing their record. People got really upset. The Jehovah's Witnesses got charged with disturbing the peace. They filed claims saying, both the freedom of speech and their religious freedom protected them. And the court, for the first time in 50 years, said, yeah, that's right. You're protected. And they established during this period the compelling interest test for religious free exercise. It goes back to my little chart here of what religious freedom actually would look like if we really wanted the Constitution to do what it would be doing to protect religious freedom. They said, look, if government's going to burden religious exercise, it has to pass the compelling interest test. So this was kind of the heyday of religious freedom. A series of cases came along and built this up, and everybody for a long time felt like, well, this is it. We understand what the law is. It's clear. This is a explicit constitutional protection in the First Amendment. Government has to, if they're going to burden us, they have to prove a compelling interest and show that it's narrowly tailored. The steps they've taken are narrowly tailored to meet that interest. In 1990, there was a backlash on the Supreme Court, not so much against religious freedom, but against what they felt like was an expansion of the court's powers in general, right? You guys will recall, since you're lawyers, this period of time is also the same time period where things like abortion was considered a constitutional right. There's a lot of expansion of personal rights. And you had a number of people on the Supreme Court who thought, this court has gone crazy, right? The Warren and Burger courts are out of control. They're just giving rights everywhere. We need to pull back on the authority of the courts. So in 1990, you had a man named Al Smith, He was a member of the Klamath tribe from Oregon, and it's a long, convoluted case. Bottom line is he got fired for using peyote from his job. Went up to the Supreme Court sent it back. He kept winning in the lower courts. He won in the Oregon Supreme Court. Finally gets up to the US Supreme Court. Everybody is arguing the compelling interest test. So the Attorney General for the state of Oregon is arguing, hey, we have a compelling interest to regulate peyote. Al Smith is arguing, you don't have a compelling interest, and I should be able to use peyote as part of my religious beliefs. He did it as part of a religious ceremony. And everyone was kind of waiting for the decision. Justice Scalia wrote an opinion where he jettisoned this entire body of law in one foul swoop. No one had even briefed what he came up with. He came up with a whole new test for religious freedom under the Constitution, and he said, look, if a law is neutral and generally applicable, and it just happens to burden someone's religion, it's constitutional. We don't care. So just think about the implications of that for a minute. If you are Catholic and prohibition is the law, and it's neutral and generally applicable, that means you cannot engage in your Catholic Mass. If you're Jewish, you cannot engage in Jewish Seder. Two of the most central practices of two of the world's biggest religions could easily just be shut down under this constitutional test. Well, needless to say, everybody was taken aback by this ruling from Justice Scalia. Nobody saw it coming. Interestingly enough, the Attorney General for the state of Oregon thought about arguing this. He came up with it on his own and thought about making the argument. And his staff and other people, when he mooted the case, said, what are you talking about? That's not the law. Get off that. The law is just the compelling interest test. What are you doing? So he jettisoned the argument. Scalia came, and on his own, Scalia came up with it separately and said that was the test. Fascinating. But what that means is there was almost no protection for religious liberty in 1990. So, and what I find just incredibly fascinating, a whole bunch of coalitions of different people got together to pass statutes to protect religious liberty in response to the Smith decision. And it was a weird set of bedfellows. You had the ACLU joining with the Christian Legal Society and the Southern Baptists, Republicans and Democrats. It's like Ghostbusters, cats and dogs living together, right? I mean, it was just a weird scenario. But they all got together and almost unanimously passed a statute called the Religious Freedom Restoration Act. That statute was supposed to apply to everything, all federal law, state law, local law. Basically said, look, because Smith is such a bad decision, we are reinstating the compelling interest test. This is where the law becomes a horrible, jumbled mess. The Supreme Court didn't like it. They said Congress overstepped their bounds, so they said RFRA can only apply to federal law. Then a coalition of folks tried to get together and pass a land use statute that at least said, well, when local entities get together and burden your religious freedom rights in land use, and if you're like in prison, then the compelling interest test will apply. Between 1993, when RFRA passed, and 1998, let me back up a little bit. The Supreme Court overruled RFRA as to the states, so it only applies to federal law. You had this massive coalition with absolutely no opposition in 1993. After that 1998 decision, that coalition had completely fallen apart. I mean, just completely. And to this day, they have not been able to pass a law that will get passed what the Supreme Court ruled in 1998. What happened between 1993 and 1998? It's only a 5-year period, right? You wouldn't think that things could change that dramatically. What happened was that this is about the same time that the LGBT movement was really starting to get some steam. They realized that RFRA could potentially be used by shopkeepers and people who are had housing complexes, like apartment building owners. They realized that those people could potentially use RFRA as an excuse not to rent or not to service folks from the LGBT community. So by the time 1998 came around, they had completely backed off of any support of RFRA and a statute that would replace it. And that's why where we are now then is this, I have this as yellow because we're in a period of time where the constitutional protections for religious liberty are all statute-based. They're not constitutional, which means they can change, they can be revoked. I just read an article just the other day in the New York Times talking about how much buyer's remorse there is on the left for RFRA. Like, yeah, everybody was behind it at the time. Now we think it's the worst thing that ever could have happened. Almost no state is successfully passing a state-level RFRA. They call them mini RFRAs, mini Religious Freedom Restoration Acts that apply just in your state. People here have tried to get them passed in Colorado. There's fierce opposition for all the same reasons. They see them now as discriminatory statutes, which they never were and they were never intended to be. But if you read CNN, like a CNN article, they'll say, the state of Georgia was trying to pass a, scare quote, religious liberty bill. All they're trying to pass is the equivalent to the federal RFRA statute that everybody was behind in 1993. But now, folks on the left are terrified of these statutes. So that's where we are. The reason it matters is because we only have statutory protection and not constitutional protection, we're starting to see some severe breakage in things. In 2010, the Affordable Care Act, Obamacare, they included as part of that the mandate, right, that companies had to give out birth control, even if that birth control violated their religious beliefs. Excuse me, that's where the Hobby Lobby case comes from. That was the first time in American history that the government tried to force someone who was of the majority religious faith to violate their religious free exercise. The first time. In all these other cases that you had going back into history, it was always someone of the minority religious faith who didn't have the political will or ability to protect themselves. This was the first time you saw the federal government try to actually burden the majority religion. They were protected by RFRA, but they barely won. It was a 5-4 decision, right? And the Supreme Court said, well, you're burdening their exercise, and under the compelling interest test, you can't force Hobby Lobby to give out birth control against that they say violates their religious beliefs. Similarly, we just saw coming out of the Ninth Circuit very recently a situation where pharmacists were forced to dispense abortifacients against their religious beliefs. You kind of have to put yourselves in the shoes of the pharmacist and of Hobby Lobby. So in their view of abortifacients, or that what they are giving out are pills that cause abortion, right? So to them, that's the equivalent of handing someone a gun to go kill somebody, knowing that the person with the gun is going to go kill somebody. And they said, it violates my religious beliefs to be complicit in that. I cannot do that. Now that is not my personal religious belief, but it's theirs, and it's perfectly logical within its premises, right? So the Ninth Circuit upheld that law. The Supreme Court didn't take cert on it. Justice Alito noted that it was an ominous sign for religious freedom. Finally, we get down to the case that is kind of front and center these days, which is forcing business owners to do things that violate their religious beliefs. Namely, right now, the cases that are most prominent are forcing people who are in various service industries to cater same-sex weddings when they say that doing so makes them complicit in a sin. I want to jump into these cases real quick, and then I'm going to force you guys to actually help me solve the problem. Since society as itself can't solve the problem, we are going to do it, okay? I'm going to give you fair warning because I really want some comments, and I should have warned you ahead of time, but this room's like all wired up. And earlier when I was just in here with one of you, yes, Mr. Luck, Harvey, we suddenly heard this voice come from the roof and somebody from our IT department was talking. So everything you say is being heard by other people, just so you know. But there's microphones zoomed in, so you can just talk and the microphones will pick it up. I want to get your thoughts on how we can solve this dilemma. I'm going to lay it out for you. I'm going to try to lay out both sides of what these cases are really about. I don't want to get lost in the weeds on just any one case. I don't want to get lost in the weeds on just the case coming out of Colorado or our cake maker case. I want to focus on the cases more broadly. So there's a series of these across the country that have been popping up, and they all tend to follow the same basic fact pattern. It's actually the same basic fact pattern I mentioned here. You have a majority who passed a law. That law is burdening someone from a minority religious viewpoint, and the person in the minority religious viewpoint is asking for an exemption. They're saying, we don't want this law to apply to us because we have our religious exercise is being burdened if it does. And how do you handle it? Okay, so the fact pattern here is generally the same. It's photographers, cake makers, flower shop owners who say that it will violate their religious beliefs to participate in or cater to a same-sex wedding. Simultaneously, you have a same-sex couple who comes in and says, hey, we'd like you to make a cake for our wedding, or we'd like you to provide flowers or whatever. And the owner of the shop says, I'm sorry, I can't do that. It violates my religious beliefs. their beliefs go like this. I believe that same-sex relations are a sin, and that if I help cater your wedding directly, I am going to be complicit in that sin. So you're asking me to basically disobey a direct commandment from my God, and I can't do it. How do we handle the problem? You should know a little background here. These people, the folks who are refusing to cater to same-sex weddings, are receiving death threats. This woman is a young mom named Elaine. She had a small photo studio in Santa Fe. When her case started to go public, she was a mother of young children. She had people calling her home, threatening to burn her home to the ground. She had people calling and threatening to kill her children. She had people yelling at her on the street that they were going to kill her and her children. Same with Jack Phillips from Masterpiece Cake Shop. There are other statutes out there right now. In fact, one is being proposed in Idaho as we speak, suggesting that lawyers should face the exact same type of laws. In other words, if a lawyer refuses to represent someone because it violates their religious beliefs, if that person is in one of these protected categories, including sexual orientation, then that lawyer could be brought up for engaging in professional misconduct and potentially be disbarred. That's being proposed by the ABA on a national level, and is being proposed in various states. Something else to think about as you're trying to help me find a solution here. What are the burdens on the individuals involved? For the people providing the services, what we would be asking them to do is to choose between their faith and their occupation, right? They can have one or the other, but they can't have both, is what the law would be telling them. So that has an odious history in the history of mankind. The English Test Acts provided that Catholics could not serve as lawyers, barristers, school teachers, or in any job that had more than 2 apprentices. Catholics did it to Protestants, Protestants did it to Catholics. In Nazi Germany, it was done to Jews. Muslims have done it to Christians, Christians have done it to Muslims. Telling people you can either choose your religion or you can choose your job is something that is one of the hallmarks of violating religious freedom historically. It's a major burden that we put on people who don't comport with what the government thinks they should be believing. That's a major burden that they face. Simultaneously, though, the folks who go into these shops and all they want is someone to make a cake for them that they can take to their wedding, and they get rejected because of their lifestyle, and a key part of what they see as a key part of their identity, they suffer a dignitary harm, right? And it's not a harm you can just dismiss. There is a harm when you walk into a place of public accommodation and someone says that, well, because of who you are, I'm going to reject you. You need to go somewhere else. So that's the harm that they face. The question is, how do we resolve this? How can we come to a solution for all? If we recognize, and I hope all of us can, that religious liberty is for everyone. It's not just for these people, right? If we hurt them and violate their religious liberty, we're really just violating our own. How can we come to a solution that helps everyone here at least get some semblance of their rights protected? That's what I'd like to discuss, and I'd like to hear your thoughts. And I'd like to open it up, and I want to kind of brainstorm together. I don't want to get lost in the specifics of the cases because each case has its own facts, and the statutes are a little bit different. But as a broader principle, how can we protect everyone's rights? Is there a way? I'd like to hear your thoughts. And I'm going to get a drink of water while you're thinking.
I have one thought. It's
Yeah.
not my area. So.
Shout it out.
If you had intermediaries, right, who can purchase, at least in the case of goods, some of these goods, then they're general buyers, they're not involved in any particular practice that could be objectionable to anyone's religious beliefs. They can buy the goods, and then then they can sell the goods to people who wish to buy those goods to use them for same-sex ceremony. So some form of intermediation might help a little bit.
Okay, an intermediary, and that was attempted a little bit in the Hobby Lobby situation with the birth control mandate, where they would fill out a form and it would still go to someone else to be an intermediary. Now, there's some people who would say that's probably okay. That might resolve some of the cases. My guess is there would still be some people who would say, I'm still complicit in this, right?
And then there's some things you can't intermediate, like photography, right? I mean, that's a service. It's much harder to...
And it's a talent, right? So, well, but you should know, in none of these cases that have really gone up into the courts has access been a problem. And what I mean by that is, there's always been another cake maker like a block away. There's always been another photo studio very close by. So access is not an issue. It's not a situation where this is the only game in town. Okay? So that relates to that in some level. Yes?
And I think that latter point is probably the crucial one. I mean, to my knowledge, there's never been a right not to be offended or to not have somebody offend you. And I think one challenge is trying to distinguish between, the situation where a gay couple can't get the service at one particular cake shop, but can everywhere else, compared to a situation where somebody, because of the color of their skin, in a whole city, can't find a hotel room to stay in. So it's offensive to be turned away because of who you are and have to go one block down. But I don't think that rises to the same level, of not being able to find anywhere to go.
Right, and at least one scholar has proposed that as a solution, to say, like, look, if we're in a place where there's plenty of options, then the law should tilt in the favor of the service provider. If we're in some small town where there's only one cake maker, then the law should tilt the other way, because the burden becomes different in both scenarios. That's one idea that one scholar has thrown out there. It kind of relates to what you were talking about. What other ideas do people have? How could we address this, Martin?
So two, one on the legal level, which I agree with what you're saying, is that, a fundamental concept in contract law is the duty to mitigate, tort law, duty to mitigate. Even here, that couple can mitigate by going to another vendor. It goes into the formal analysis, I think, both as to how strong is the burden on them, also whether there's a less restrictive means available for the government to vindicate the public accommodations law or whatever's at stake. On a political level, though, I had the chance to speak about religious freedom to the LGBT law conference 2 years ago, and the reason I took that invitation was to say to them that while the activists in that community are scared of religious freedom, really hypothetically, based on hypothetical situations, not actual situations, I said you need to look how it goes for LGBT individuals in societies that don't respect religious freedom. They get pushed out of windows, they get hung, it's terrible. And so attacking, when you say religious freedom for everyone, is for everyone, you're exactly right. It's also for gay and lesbian individuals who may feel threatened by hypothetical situations about religious freedom. So there's a huge teaching need in our society about that.
Yeah, absolutely. It's absolutely for everyone, including LGBT couples. And on that point, let me tell you a little bit about what the LDS Church has done here, because I know we have a large LDS audience. The state of Utah a while back was considering various laws to protect LGBT citizens in housing, employment, healthcare visitation rights, things like that. And the legislature was falling along all the same lines that you tend to see. You had the vast majority of people were our far-right Republicans who said there's no way on earth we're ever going to pass this statute. You had people on the LGBT side who were digging in and saying, you have to do it, you're burdening us, all this stuff. And it was all the same things, and nothing was ever going to pass. At the time, the Utah legislature was 87 out of 104 were Republicans. The vast majority of those were LDS. And they had dug in and just said, this bill came along to protect LGBT citizens, and they just said, we're not going to do it. Then the LDS Church came out and basically made a statement and said, we support this statute. We support protecting LGBT citizens in housing, employment, visitation rights in hospitals, various other settings. And the statute passed. At the time, I think still today, Utah became the state with the most protections for LGBT citizens in the country. This was 2015. It hasn't been that long ago. We haven't seen any other state be able to pull off that type of compromise. What they did was they called the Utah Compromise, and what they did is said, like, we're going to protect LGBT citizens in all these cases, but we're going to exempt out those rare cases where there are people who have religious objections. The extreme left was not happy with it. The extreme right thought it was too much of a compromise. In my experience, if both the extreme left and the extreme right are upset, you've probably hit somewhere close to where you want to be. Okay, that's my opinion anyway. That said, that doesn't address this issue. Utah doesn't have a public accommodations law, so they didn't have to solve this problem per se. So we're still left with trying to resolve it. In the church's brief, the church filed a brief in this case. This is Masterpiece Cake Shop. It's going up to the U.S. Supreme Court. Oral arguments are December 5th. The opinion probably will come out right at the end of the term in June. I don't want to get into the specifics of the case and get lost in the weeds. I only want to tell you where the LDS Church, what position they took. The case is largely focused on freedom of speech. And can this person as an artist be forced to engage in speech that he doesn't want to engage in? And that was a strategic decision made by the litigators. Makes sense. The church filed a brief and it was written by 2 scholars, both of whom have been very vocal advocates for LGBT rights. They had advocated for years in support of same-sex marriage, had advocated for equal treatment of LGBT citizens in other contexts, and they actually started the brief off by saying that it's telling that it was the LDS Church and several other religious organizations joined together in this brief. They said it's telling that they hired 2 scholars who have traditionally argued for LGBT rights to draft this brief. And what they went on to write is that forcing someone to engage in what they see as a religious ceremony, a marriage, is essentially violating both the Free Exercise Clause and the Establishment Clause. It's violating the Establishment Clause because it's forcing someone to participate in a religious exercise that they don't agree with, right? It would be like forcing me to go get married in the Catholic Church, all right? Or participating in a wedding or some religious ordinance that I don't want to participate in. Simultaneously, it burdens his religious exercise because he feels if he participates in this wedding, he will be violating God's law. And you're kind of making him have a choice. You can have your job and face eternal damnation, or you can be saved and have no money. That historically is a problem. And the church has argued, look, Supreme Court, you protected LGBT citizens when it came to same-sex marriage and the right to have their marriages treated the same as heterosexual marriages. It's now time to protect people seeking a religious exemption. They also pointed out the difference in the harms. They acknowledge that the dignitary harm is real and you can't ignore it and you have to take it seriously. But they pointed out, and this kind of goes to what you were saying, they pointed out that the dignitary harm, it's a one-time harm. You're offended, and it's real, and you leave, and you know that there's someone out there who rejected you because of who you are. But you can go to another cake shop, you can get a cake, you still get to be married, you still get to have that wedding recognized by the government, and you get to live the rest of your life in your chosen profession with your chosen spouse, really burden-free. For the people on the religious side, they either have to spend the rest of their life knowing that they are violating what they believe are divine commandments, or they have to spend the rest of their lives not doing the only occupation that they know how to do. And it's something that will be with them the rest of their lives. They can't escape that. They will never be able to do their chosen occupation. So what the argument that these scholars made on behalf of the church was, look, when you weigh those 2 burdens, this burden outweighs this burden significantly, and so we should go ahead and grant the exemptions. And that's the argument there. So we fleshed it out a little bit more. What other thoughts do people have? I'd love to hear what other views or ideas people have, ways we could try and solve this dilemma. Yes, Russ.
What if you had a registry where somebody who has an occupation where they want to publish to the world that that their religious belief would prohibit them from providing this particular type of service? It was open, it was public. Anybody walking into any shop could Google it up on their phone and understand that if I go to this cake shop, this person will not do cake for me if I'm a member of if I'm looking to have a gay wedding. Just an idea.
Yeah, and scholars have proposed that, and I think it's conceivable, and then I'll come to you. And the only worry I have is, I'm not going to, I promise I'm not trying to disparage the entire LGBT side of this debate, but there certainly has been quite a bit of violence coming from the LGBT side. We've seen bricks thrown at establishments, we've seen anthrax sent to establishments. Even in Colorado, we saw one church that had their scriptures burned on the steps of their church because they had opposed same-sex marriage. So the only question is, could we do that without these people being threatened and receiving violence for having those things posted publicly? If so, then I think it's a potential solution because it avoids the problem of the dignitary harm of when you go in there, right, on some level. I don't know how confident I am that we can avoid the threats and the violence and everything, but I do think it's something that should be explored. We have a hand here, and then we'll come over here and then back there. Okay, yes?
At least until there's some sort of resolution, isn't one of the issues that right now you've got activists who would target folks on such a list? I mean, they're essentially gunning to establish this right or this, they want to nail these guys and get them out of business. So such a list would be putting a target on them.
Yeah, no question. And let me emphasize, I do think the threats and the violence and everything are coming from the extremes on this side, right? It's not the vast majority of people. It is the extremes, but those extremes are out there. We can't ignore them, right? We had a hand here and then back here. Yeah.
Same kind of comment. I don't have anything else.
Okay, so worried about having a target on your back? I mean, at what point, my concern, and I don't want to be hyperbolic here, so please take this with a grain of salt, but I worry that it's almost like having a Star of David on your shop, and what would happen with that, right? What kind of threats would come? Hi.
I think for me, it's a question of whether the list is voluntary, right? If it's purely voluntary and I want to say that that's the case, yeah, there may be a target, but also the harms the violence and the harms we're concerned about, those are clearly violations of other laws. So the fact that someone may choose to violate the law doesn't, there are punishments for that. But I don't know if that resolves the problem for me. One of the questions I have about this, though, is when we're talking about a solution where we have exemptions, is it limited? And we've talked about, service that attend art and cake and things that have speech implications. What if we're talking about somebody who's letting out hotel rooms and they object to letting same-sex couples stay in their hotel because they feel like that's a violation of their religious liberty, a reasonable thing? But now you're talking about a shelter, an essential, service. Does that change?
I think it goes back to what Trent said, which is, what are the specific facts? Is there a hotel right next door? Is there another place right there that they can go to? Are they the only hotel in town? If it's my hometown, it might be the only hotel within 200 miles, right? Maybe that matters. And maybe we should take that into account. There was a hand, Brian, and then here, and we'll come back to Martin. Yes.
About the fear of lists and retaliation, there's no way around that. This is the internet age. You can go to, the pro-life groups that they just find out who the abortion doctors are and they put their face on the website and this is their address and that's it. You don't have to have a list. Someone's always going to be able to find out that information and it'll eventually get publicized. There will be threats or there will be boycotts, but I don't think that can be in any sense of something that we try to work around because it's nearly impossible to work around. It's always going to be a problem.
Well, and to our point over here, we have laws, if there are threats and violence, we have laws preventing that, presumably, right? And I think you're right. In this age, extremists who are motivated enough will find the people that they want to target, right? That's a good point. You hear it, and Martin, and then I need to move on to the last part of this.
I think bespoke services are different than a hotel room, for example. That's essentially, it is what it is, right? And if you're going to turn people away because of their beliefs, I think they're in a different category.
Well, and that matters too. So a lot of these, almost all of these cases, the cake maker and others say, look, I don't have a problem with selling my products to LGBT citizens. Come in and buy a cake. It's when you're asking me to participate in the wedding that makes it different. And so these cases are unique in that regard. And it's a little bit different from the hotel owner. Hotel owner is more like, I'm not going to sell you cookies, right? Because there's nothing about the room. But I can see also how you could get there and see why someone would feel like they're complicit in something they shouldn't be. Martin, why don't we'll give you the last word and then I'm going to move on.
So the list idea, we don't have to hypothesize about how that would work because there was a fairly easy religious exemption under Title IX for colleges to get. Some applied for it, and during the Obama administration, under pressure from the LGBT community, they decided to publish the list, and immediately gay activist sites began publishing what they call the list of shame and promoting a secondary boycott. And they were contacting colleges that would recruit students, employers that would recruit students from those colleges and so on to come against them. So the boycott pressure is huge. I mean, whole states have been boycotted and so on. And so I don't think that solution is going to work too well.
Yeah, well, it's not just boycotts. I mean, it's death threats and all these other things. So, okay. I talked about the Muslim ban and how that's a threat to Establishment Clause. I just gave an example. Again, we could spend an entire semester talking about Establishment Clause issues. These are just examples of when Trump first threw it out there and said, I want to ban Muslims. It was shocking how many people supported that. People who think that they are normally in favor of religious liberty, I think were ignorantly thinking or misunderstanding and not understanding what they were doing. All right. How then, if you go back to your congregations or wherever and you're explaining to people and they're trying to get, people have anxiety about religious liberty or they want to know what to do, There's two questions they can ask themselves. The first thing they need to do is identify whether or not religious liberty is being threatened. And I put this up here precisely to avoid people from inadvertently threatening religious liberty without realizing it. First question they can ask is government promoting or favoring one religion over another? If so, then religious liberty is being threatened. Second question is government preventing someone's exercise of their religion? Again, if so, then religious liberty is being threatened. From there, the question is, what do they do? Once they, and this can happen in schools, it can happen at local government, county government, state level, federal level, right? If you see something like this happening, I just had someone call me last week from Michigan. School district was preventing a little girl from writing about God in one of her homework assignments. So the answer here is yes. The question is, what do they do? I've got a little video I want to show you that'll at least give you some ideas. And my hope is that, we're not going to come up with every idea in the world, but my hope is that from watching this video and thinking, ideas will come to you. And you'll be able to think of things you could do in your own communities, what people you know could do to try to protect religious liberty when they realize it's being threatened.
You know, I would encourage everyone, no matter where they are, no matter what station of life they're in, no matter their educational background, to educate themselves on the issues in the defense of religious liberty. They need to know why it's so important, what the challenges are, and to become aware of the local issues in their own neighborhoods, in their own communities, in their own cities. When those issues come up, they're there, they're ready, and they're able to respond in an informative way.
They can do that through op-eds. They can do it by giving talks at Kiwanis Club. They can do it at the auxiliaries of any of their churches. They can teach. They have that experience. They can teach the principles of religious freedom throughout the country.
Religious leaders and believers must unite to strengthen our freedom to teach what we have in common, as well as to teach and exercise our very real religious differences. We must walk shoulder to shoulder on the same path in order to secure our freedom. We must also insist on our constitutional right to exercise our beliefs and to voice our conscience on issues in the public square and in the halls of justice. These are the rights of all citizens, including religious believers, leaders, and organizations.
I think what the case actually has stood for is that religious liberty and religious freedom is not dead in America. That these are still issues that courts are not only willing to take seriously, but they're willing to defend. And that gave me hope. It gave me real hope to have that unanimous decision. That basically told religious organizations and entities throughout the country is that, you know, if this is an issue that you hold dear, you know, fight for it. You know, fight for it.
One last thought I want to share, and then I'll close, and we can open it up for more questions or discussions if you want, is I mentioned earlier one of the founders' reasons for believing in religious freedom was that they felt like you could promote virtue, and that from virtue we would have a society that could govern itself. I don't think religious organizations, this is not a legal thing, this is what lay people can do. I don't think religious organizations by and large are doing a good job of helping people see all of the virtue that they are helping bring into the world. But if you look, I just Googled just the other day, I just Googled like church service project or something, and just came up with, it was endless headlines. I could have filled 20 PowerPoint presentations of various churches and news stories about churches doing religious service. And out there helping people, helping flood victims, helping, you know, to the homeless people. Just, I mean, any type of service you can imagine, it was happening. We need to do a better job of letting people realize that religious freedom does lead to positives in society, tremendous positives. I did not grow up in the faith that I am today. And the reason I am the faith that I am today is because I saw the example of people who were living in a way that was different than those around me. And it caught my attention. And I thought, wow, I want what they have. And I started to ask questions. I think as a society and as religious believers, we can do more to help people understand the good that comes out of our churches and our service and all of the things that we're doing. We can do that through all of these various avenues. We can do it through various posts and things. I do think it's crucial that we do it, though. We need to help people understand that religious freedom matters. It matters for all of us across the board, no matter our beliefs or non-beliefs. And it matters because it's what makes America so great. It helps unite our society. It helps bring people together in a common cause. Thank you. I'm happy to take any questions if anyone wants, or you can